Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in this series of Law of Torts, we are focusing on general defenses against tortious liability, and in that series, this is my fourth video where we are going to understand inevitable accident. Now, this is one of the very important defense, and you need to carefully understand what is inevitable accident, because sometimes there are chances that you get confused between inevitable accident and act of God. Now, inevitable accidents are something happened due to some or the other human actions, whereas act of God is something connected to nature. But that's not so easy to understand these two. You have to understand case laws also to draw a line between these two defenses. I am going to discuss both the concepts in detail. Here in this video, we are going to understand inevitable accident, and in my next video, we are going to understand act of God. And here I am discussing as many as 8 case laws, and in my next video also I am going to discuss a lot of case laws. So that way I will also draw a clear line or the difference between inevitable accident and act of God. Now for next 2 slides we are going to repeat the first video where we'll understand what are the defenses available, and for inevitable accident I have already shown one slide in my initial video, that is video number 1. That also we are going through quickly to understand what exactly is the concept, and then we'll understand everything in detail. Not taking much of your time, let's get into the first slide. First thing first, in the first video we have listed as many as 11 general defenses available with the defendant against tortious liability, and they are voluntary non-fit injuria, plaintiff the wrongdoer, inevitable accident, act of God, private defense, mistake, necessity, statutory authority, act of the state, parents having parental or quasi-parental authority, and acts causing slight harm. Here comes the illustration for inevitable accident, which we have already discussed once. I'll quickly brief this because we have a similar case law also available. What happens? Few friends go for hunting, and one of the person shoots an animal with his gun, and the bullet, instead of hitting the animal, hits a tree and bounces back and hit one of the friend, and that friend dies. Now here the tortious liability on the person who has shot by the gun can be defended, because whatever he has done with due care, and bouncing bullet hitting another person is over and above his control, and he can always take the defense of inevitable accident because it was uncontrollable by him. That's what we need to understand, and we have a very beautiful case laws to understand this particular concept in my future slides. Let's get into my next slide to understand what is the concept of inevitable accident, and later let's get into different case laws. This is the slide where we are understanding the concept of inevitable accident. Before we understand what is inevitable accident, let us try understand the meaning of accident. I have given there an unfortunate incident that happens unexpectedly and unintentionally, typically resulting in damage or injury, is an accident. We all know the concept of accident, and let's go a little further to understand the meaning of inevitable accident, which is if such accident, whatever I have told in the above, like whichever incident is happened unexpectedly or unintentionally, which is resulting in damage or injury, that could have been foreseen and avoided, then it becomes negligence. If that couldn't have been foreseen and avoided, in spite of reasonable care on the part of the defender, then we are calling as inevitable accident. Please understand the difference. If it could have been foreseen and if the incident happens, then that is negligence or rash thing. But if it couldn't have been foreseen and avoided, and there was reasonable care in the part of the defender, in that case that becomes an inevitable accident. So in a nutshell, all that we need to understand here is an incident which has happened unexpectedly and unintentionally, which is usually resulting in damage or injury, is accident. If the same couldn't been foreseen and avoided in spite of taking reasonable care, in that case we are calling it as inevitable accident. And as I have already told, there is something connected to human actions here, whereas in act of God we are discussing something related to natural forces. Now let's get into different case laws to understand what exactly is inevitable accident and what courts have held in these scenarios. Before getting to case laws, always remember that in general defenses, defendant wins the case. When the general defense is actually proved, defendant win the case. So we need to understand all the context in the angle of defendant as the person who has committed some or the other thing, and when he wins with the defenses, those are called general defenses against tortious liability. Here what happened in this case, as the illustration, few of the people went for hunting and the defendant tried to shoot a bird, and the bullet, instead of hitting the bird, hit a tree, rebounded and hit the eyes of the plaintiff. Now plaintiff asked for the compensation, but in the court defendant told whatever happened was over and above my control. I have taken sufficient care, but this was inevitable because this couldn't have foreseen by any of the people there. So whatever happened was over and above my control, and hence it need to be considered as an inevitable accident, and there is no matter of compensation or whatsoever. And the court accepted the same, and it was held that as the incident was inevitable accident, the defendant is not liable to pay any compensation. I hope that is very clear. With that, I move to the second case law. The first case law that we have discussed, Stanley versus Powell, is one of the very important case law, and whenever we are discussing about inevitable accident, we have to discuss that particular case law, and that is one very important aspect you need to remember. Now coming to the second case law, that is PADMAVATI versus DUGGANAIKA, is also very interesting, where the defendant, that is DUGGANAIKA, had a jeep and Mohideen was the jeep driver. One day when Mohideen was passing through in the jeep, two strangers asked for lift and Mohideen agreed, and on the way the right hand side front wheel of the jeep flew away and the jeep got toppled and all of them got injuries. As an end result of the serious injury, Ramakrishna, one of the strangers, has died. Now Ramakrishna's wife Padmavati put a case against DUGGANAIKA, the owner of the jeep, and the driver Mohideen and the insurance company, and she asked for compensation of rupees 45,000. But in the court, DUGGANAIKA took the defense of inevitable accident, saying that the right hand side front wheel of the jeep fleeing away or the jeep getting toppled, all of those were inevitable accident. So there is no matter of giving compensation, and the court also agreed for the same. This particular case law, that is Padmavati versus DUGGANAIKA, is very important for the voluntary non-fit injuria defense also. Remember, in Padmavati versus DUGGANAIKA, it was argued that the consent was implied by taking the jeep, and that way it was proved voluntary non-fit injuria defense also, as well as whatever happened, the wheel flying away or jeep getting toppled, all of these were inevitable because it could have not been foreseen, and there was due care from the driver also while driving. He was not negligent, he was not rash, he was not doing any nonsense business. That way the court agreed both of the defense, and defendant could not get any compensation. I hope that is very clear. With that, I move to the next case law. The third case law, that is Holmes versus Mathur, is a very interesting case law. What happened here? The defendant servant, who is a horse rider, was carrying a horse on the road, and suddenly a dog came and started barking at the horse. Now the horse got frightened and started behaving crazy. Because of the act of the dog, the horse gone crazy, and that ended in the injuries to plaintiff. Now he puts a case asking for compensation, but the court here says the defendant was not liable as whatever happened was an inevitable accident. This is what you need to understand. Here there was no negligence by the rider of the horse. He was taking all care possible, but he couldn't have foreseen that a dog comes all the way and started barking at the horse, and then the horse getting frightening and doing all these crazy activities couldn't have been foreseen. So that way this becomes an inevitable accident. I hope that is very clear. With that, I move to the fourth case law. The dog story continues in Brown versus Kendall. Here what happens, both plaintiff and the defendant had dogs and they were taking them for walking. Now the dogs started fighting and the defendant tries to separate them with the help of a stick. Now that stick hits the plaintiff. Now they both start fighting. Earlier it was dogs fighting, now plaintiff and defendant start fighting. The plaintiff's case was the defendant has done trespass, he has done assault and battery, and hence I should get compensation from the defendant. But in the court it was held that the defendant is not liable for the injuries suffered by the plaintiff as it was purely an accident. The defendant had no intention to hit the plaintiff with the stick. What had happened was unforeseen, and even after taking sufficient care, it has hit the plaintiff and there is no matter of compensation whatsoever is what held in this particular case law. The fifth case law that I am discussing here is a very interesting case law because this is an example for plaintiff the wrongdoer as well as inevitable accident. Now how we need to understand this case law is what I am going to discuss, that is in the case law of Assam State Corporation Federation Limited versus Srimati ANUBHA SINHA. What happened here? ANUBHA SINHA was a tenant in the plaintiff's property and she has informed the plaintiff that there are some electric wire issues and there are some safety concerns, and even after reporting, the plaintiff was sleeping nicely, not taken any action, and this finally caused a fire accident one fine day which ended in burning the entire property. Now plaintiff in the court asked for the compensation from the defendant, but defendant told there were some electrical wire issues and I have already informed those to plaintiff and plaintiff has not taken any action, and whatever happened later was completely an inevitable accident because I could have not taken any action, so there is no mistake from my end, so that way it is an inevitable accident. As well as though I have informed to the plaintiff has not taken any suitable actions to protect the property, that way it becomes plaintiff the wrongdoer also, and the court held in favor of defendant, and that takes us to the next case law. The sixth case law that we are discussing here is Sridhar Tiwari versus UP State Road Transport. What happens here? A bus driver was driving a bus and all of a sudden a cyclist came in front of the bus, and to avoid any injury to the cyclist, the bus driver tries his best to avoid the accident, and as an end result, the bus hits another bus. In the another bus, there was a person by name Sridhar Tiwari who was traveling and he gets injured, as well as his properties like watch, glass, etc. got damaged. Now he goes to the court and asks for the compensation from the driver. The defendant driver in his argument says that whatever happened on the road was inevitable. He could have hardly foreseen such kind of incidents happening, and he has taken sufficient care and he was not doing any rash driving, and with all these facts this should be considered as an inevitable accident, and court also agrees his defense and the plaintiff doesn't get any compensation in this particular case law. I hope that is very clear. From next case law, that is last two case laws, let us see other angle to all these case law. Let's have different perception. I'm taking to the next case law. In the introduction itself that I have told, there is a small difference between act of God and inevitable accident. Sometimes they both come together and you might get confused. Here in this case law, that is yes Vedantacharya versus Highway Department of South Arcot. Now we can see both the angles. What happened here? Because of heavy rain and flood, a vehicle got plunged into a stream. Now because of that, one person died and the plaintiff asked for the compensation. Now highway authorities said that there was heavy rain and flood and hence it needs to be considered under act of God or under inevitable accident. But the court very clearly told in this incident that this is not an inevitable accident because there was no notice on any danger coming in. There was no sufficient care and protection from the highway authority, and this cannot also be seen under act of God because with the technology today we can forecast many things like rain and flood, and the highway authority has not put sufficient effort to understand that and give notice to the people. That way, in both the defendant has failed and the plaintiff has won the case. I hope that is very clear. With that, I am taking you to the last case law. General defenses. We need to note one very important aspect, that the defendant should be able to use the defense properly after ensuring that he has taken sufficient care and there was no negligency etc. from his side. What happens if that is not justified? That is what we are understanding in the case of the Oriental Fire and General Fire Insurance versus Rajarani Surendra Kumar Sharma. What happened in this case law? The defendant had a tanker and the defendant has parked that particular tanker in a zone where it shouldn't have been parked. There was no lights and the tanker also was parked without any indicators or lights. Now the victim of the case, who is the husband of the plaintiff, was coming in a motorbike and he couldn't see the tanker parked there. He comes and hits the tanker and dies instantly. Now his wife, that is Rajarani Surendra Kumar Sharma, puts a case and the defendant tries to say that he has done good things, but the court says it is not an inevitable accident because the tanker was not parked in a place where it could have been parked, and further there is no care from the tanker owner or the insurance company or whosoever by putting lights etc. in the place which is being parked, or the lights of the tanker were not kept on. All of these are negligence and there was no care whatsoever, and hence the plaintiff won this case. The defendant could not prove that it is an inevitable accident because there was no sufficient care taken by the defendant. That is how you need to understand. So it becomes very essential and important to ensure that the defendant has taken all due care and there was no ability available with the defendant to foresee any of those incidents. Only in that case defendant wins the case. Otherwise definitely the plaintiff won the case and will get compensation accordingly. That's what happened in this particular case law. I hope that concept is very clear. With that, I am handing over this presentation to Nishan.
Friends, we all have stress in our life, but we should always smile. That's what keeps us healthy. With that, I am concluding this session. Please subscribe our channel. Please like, share and comment our videos. Thank you. Bye-bye.